let's swing it over to Brittany to teach us something about business planning.
All right, thanks. So do you see my screen up?
Yes, we do.
Okay. I think my view is different from you guys, so let me know if we get off track. So thanks for having me today. I am happy to be here presenting on this topic. Business, kind of my ideal client is a business owner. I love the intersection of business law and estate planning. And I know a lot of attorneys who practice estate planning also do business law. So if you fall in one of those categories, this might be a little bit of a basic review for you. But a lot of estate planning attorneys, especially those new to the practice or who primarily serve in family law, hopefully this will be a good introduction to kind of the minimum things that you need to know if you're helping somebody with their estate plan and they might have an LLC or need an LLC. We intend to make this kind of a two-part series. The materials that are uploaded on the OBA include part 1 and part 2. So today I'm going to focus mostly on LLCs and how they play into estate planning, kind of what they are. And then on the next presentation, we will dig deeper into the business succession tools. So today, what I hope to cover are basics, just to make sure we're all using the same frame of reference. And then I'm going to get a little bit more in depth about complexities of LLCs. We'll talk about how it interacts with your estate plan and when and why you might need to collaborate with a more specialized attorney or especially a CPA or financial advisor. And then any questions that I haven't had the chance to answer throughout the presentation, we can go over at the end. So let's switch gears into the LLC Basics. So for purposes of this discussion, I'm going to assume our clients need an LLC. There are different types of entities. There's corporations, limited liability partnerships, and there's pros and cons to any of them, depending on the goals and objectives. But LLCs are the most flexible, and so now they're the most common. But just a footnote, many of these rules would also apply if we were talking about corporations or nonprofits or other entities when we're talking about best practices regarding documentation and things like that. So what is an LLC? It is an entity that is formed to limit the personal liability of the owners and kind of also separate the assets. The goal is to make sure that if anything goes wrong in the business operations, that the assets of the business are protected, and also if anything goes wrong in the business owner's personal life, the assets of the LLC are protected. So it kind of separates what you own into different buckets and spreads the risk. It's important to know this as an estate planning attorney because you can really add value to the relationship you have with your clients if you're helping them issue, spot, and identify circumstances where there might be gaps in their planning, especially when it comes to asset protection. Our clients come to us to talk about what happens if we become incapacitated or how do we avoid probate, but they might not know that one of the things that we can offer is a more holistic assessment of what their needs are. So when would your client need an LLC? There's really two types, just speaking broadly. An operating company, and that's when somebody is running a day-to-day business. So your law firm, for example, is an operating company. If you were starting a new business and you were going to form an LLC, that would be an operating company. a holding company typically owns an asset, and most often this is real estate, but it could also be boats or planes or things like that. So if you own the building that your law firm is housed in, best practice would be to have a separate LLC as a holding company that then rented the property to your law firm operating company. So when you're issue spotting for your client, if they have vacation homes, rental properties, even when the family member might be the tenant, commercial buildings, farm or agricultural land, if they're operating farming operations, if they have significant value of commercial equipment or significant mineral interest that are earning revenue, then it is a good idea to talk to them about whether that should be owned in an LLC if it's owned in their individual name. A couple of others that I'm seeing popping up more and more frequently are intellectual property, especially as people's digital assets increase in value, blogs become more valuable, websites, things like that. If they're making money from that, they might want to think about running that out of an LLC. And then also sole proprietorships, service businesses, and even sometimes MLMs, like wherever you fall on how you personally feel about MLMs. If your client has one, then they're probably pro MLM, and a lot of them have different rules in place on whether they can pass down the business that they're growing to somebody or not. And there's usually very specific rules that they must apply, or it goes away and goes up to their upline. Most of them have no idea about that, and so if they're successfully running an MLM business, that's also something to look into with them. There's two really kind of subsets of LLCs that every estate planning attorney should be aware of. First, there's the professional limited liability company. And if you're organized as a corporation, the equivalent of this is a professional corporation. And this is a type of entity that you would use if the business is really focused on rendering professional services, especially if it requires a professional license. And the statute regarding this lists all the different types of businesses that are subject to this. But most often when I'm forming one for my clients, they're in the medical profession. I, as an attorney, have a PLLC. Most of you probably should if you don't. And we have several veterinarian clients too, and encourage them to operate as a PLLC. An exception, and we're going to talk a little bit in a minute about the process of forming an LLC, but with a PLLC, you have to file an original certificate of good standing from whatever board supervises that licensing professional. A second type of entity is a series LLC, and a series LLC is going to be most often used when a client has multiple properties, but it really could be any asset of a similar nature. I use them most frequently for my clients that have rental properties. And the purpose of a series LLC is to create kind of an umbrella company that has separate cells, and so that you're able to protect the assets and the liabilities of each cell under that series. And just a couple of things to make note of when it comes to series LLCs is that when you're filing it, you have to file a notice that you intend to operate as a series, and your operating agreement should also include related language. The same thing with your PLLC. Your operating agreement should be drafted to include that language. Let's see. Any questions about that? We're good. So I talked about how LLCs are the most common because of their flexibility. And one of the places where they're most flexible is when it comes to taxation. So I touched on collaboration, the importance of that when your estate planning practice overlaps with business owners. If your business owner client doesn't have a good relationship with an accountant or CPA, this is a good opportunity to encourage them to develop one, because when you form an LLC, you have to determine the tax status of it. And there are some default rules. If it's a single member LLC, then it's going to be treated as a sole proprietorship. So that means for purposes of the IRS, they're going to disregard the fact that you formed an LLC, and your income will flow through to you personally on your Schedule C, and expenses will be reported there the same way. Excuse me. If you have more than one owner, then the default is a partnership, and your revenue and expenses are going to be reflected on a separate tax return, and then each partner gets a K-1. You also have the ability to do what is called make an S Corp or C Corp election. We see S Corp elections much more frequently than C Corps. Often when there is a C corporation, it's because there's an international member, somebody is planning to look for venture capital, and some people like to run medical marijuana businesses with a C Corp. But the S Corp is by far more common. Once your business owner is really kind of getting at a point where they could save money from self-employment tax by making the S Corp election, that can be a really powerful tool for them. But again, that's going to be a question that really needs to be analyzed by their accountant because it's tax planning. If you know that, so for example, if you're forming a PLLC for a nurse anesthesiologist, and you know that they're going to have high income from the beginning because they have a contract, you might make the S Corp election from the very beginning. So basically, you have the ability to be an LLC, but you can still have the tax benefits of a corporation if you elect for them without having all the administrative burden of being a corporation. Excuse me. So when you are forming an LLC, the steps are relatively self-explanatory. You just have to file articles with the Secretary of State and obtain a tax ID number or an EIN from the IRS website. If you're a business that's going to be paying sales tax, you need to register with the Oklahoma Tax Commission right away to get a sales tax number, and then you need to open a bank account. Often we find that people think that if they complete step one, that they're good to go. And if your client's a do-it-yourselfer and they're really just kind of exploring the idea of forming a business, that might be sufficient. But it's important to realize that really this is just the first step. If you want to receive asset protection and keep those liabilities separate, you really need to be doing more than registering with the Secretary of State. So step two is to properly document the LLC. For all our clients, if we form an LLC, we create a company record book, and that book includes their written articles of incorporation, an operating agreement that reflects the tax status, whether it's a holding company or operating company, the language is going to be a little bit different. And we make sure that it really reflects the terms of the actual agreement between the partners and isn't just a form document. We also draft organizational minutes and a minute to appoint a registered agent, and we create membership certificates for ours. So one of the things to keep in mind when we talk about the flexibility of an LLC, if you have a corporation and you don't have bylaws in place and you're not maintaining annual minutes and kind of those formalities, then that can be grounds automatically to pierce the corporate veil, which means you reach through that limited liability protection and can go after the business owner's personal assets. With an LLC, that's not a requirement, but it's still best practice. And so it's kind of a low-hanging fruit way to mitigate the risk that somebody's going to make the argument that you were really acting in your individual capacity instead of your business capacity. And that makes a lot of sense for most of us if we have a partnership. It's logical that we want a written document to reflect what would happen if there are any potential conflicts down the road, so that there's a fallback plan for disputes. But it's sometimes not so obvious if you have a single member LLC. In my opinion, it's just as critical, just in a little bit of a different way. If you are a single member LLC and you are also the manager of the LLC, then you are wearing both hats constantly. So while obviously, if you as the manager agree to take an action, you as the member agree with that. But it's important for purposes of disputing corporate veil-piercing arguments that you can show that you understood that you were wearing the manager hat when you made that action and not the member hat. And your operating agreement will give you specific permission to take certain actions and exercise discretion, etc. It's so much better to have this in place from the beginning and just maintain this simple annual minutes. Something that happens if you get started in LLC work is you'll find a client gets sued and then they are scrambling to have their corporate records put into place. And that typically is not sufficient. You have to keep it in time to really show that you are doing your due diligence regarding best practices. I had a client, relatively recently come to me and say, we need our corporate book and put together. And they were in the middle of a lawsuit, and that was part of the discovery, and the piercing the corporate veil was the main argument. And they hadn't drafted any minutes for 17 years, so it doesn't really fly to retroactively catch up 17 years of minutes. The other thing that is helpful about having properly documented LLCs is it helps with credibility when you are applying for loans or have due diligence inspections when you're selling the business. When you need to apply for group benefits once you have employees. This really became clear during the COVID relief, especially the PPP applications. You had to submit some of this documentation to the bank, and if you didn't have it in place, then your application didn't get processed in time. And when there was a limited amount of money and kind of a first in line receives it, it really limited people's ability to pivot quickly. Just one thing to note, if you have a entity that's going to make the S Corp election, then both your operating agreement should have necessary S Corp election language. And if you don't know what would be included, send me an email and I'm happy to share some sample clauses with you. And also, if you have a trust-based plan that owns an S Corp, your trust needs to have specific language to not trigger tax consequences upon the death of the owner. But those are just things to keep in mind. Okay, so let's talk a little bit about some of the kind of the hidden problems with LLCs or challenges. And And these are things that are great to talk to your client about, especially if they're, maybe a little bit hesitant to think that they need counsel. Some of these things will help them show the value of getting good advice down as they go. Governance matters. You can't just file the paperwork with the Secretary of State and have this magic liability shield. And there are other smaller things that have to happen to make sure that piercing of the corporate veil is unlikely to happen. So here's some commonly overlooked requirements. If you are operating as a business other than exactly how it's filed with the Secretary of State, you should file a trade name. I act in the abundance of caution in this area. It's $25 to file a trade name report, and it's super simple. It takes probably 15 minutes. So for example, I'm Littleton Legal PLLC, but in almost all my marketing, we refer to ourselves as Littleton Legal. And so I have a trade name without the PLLC, so nobody could ever make the argument that they didn't know that Littleton Legal was operating as a limited liability entity. You're required to keep the principal place of business current. This is especially critical if you are a entity operating out of another state. So a common example of this is with construction companies or roofing companies that come in after a storm. If they are a Texas company and they're setting up shop for the next year in Oklahoma, they need to register their foreign business with Oklahoma and have a principal place of business or at least a registered agent addressed here. And if they don't do that, then they don't receive limited liability protection for any claims that come up in our state, and vice versa if your client has a significant presence in other states as well. The registered agent has to be somebody that can actually receive service of process, and that needs to be updated over time. And then you have a requirement to file an annual certificate. And this is a document that honestly is probably just a revenue generator for the Secretary of State, but it tells them for $25 a year, you tell the Secretary of State that you're still doing business, you're still located at this principal address, and by doing that, your entity stays in good standing. They send you an email, and if you miss the email, then you're out of luck. And after 2 months after your renewal date expires, or a little grace period, then your entity becomes inactive and eventually is terminated. So that is a really good way to make sure you don't have limited liability protection. I mention that because clients often think they have that under control and they don't. So anytime we're doing the funding of a client's trust, or we're preparing to design their estate plan, if we have information that they have an LLC, I always, as a matter of course, check the Secretary of State records to make sure that it's in good standing. It's also, honestly, as an estate planning attorney, it's a good way to add an additional revenue stream to your practice. You can take responsibility for filing that annual certificate and helping the client keep their minutes updated. It's not a huge money maker, but it's going to keep you in touch with your client year after year and be first of mind. So another way you can lose good standing is if you haven't filed necessary documents or reporting or tax returns with the Oklahoma Tax Commission. And then you have to make sure that if your LLC falls in one of the kind of special categories like the series or the PLLC, that you are making sure that the documentation is included with the Secretary of State. You can't just declare that you're a series LLC and not have that notice filed with the Secretary. Okay, taking a breath. So here's just kind of some more low-hanging fruit tips, and these things will help you rebut an argument that the corporate veil should be pierced. And basically what it kind of sums up or boils down to is that if you want to be treated like a business, then you should operate your business like a business owner, not a sole proprietor. And you know, this applies to us as well. If you're a solo attorney, you know, most of us are formally incorporated, but a lot of us kind of think of ourselves as attorneys first, and the business owner aspect is just an afterthought. So if this isn't something that you want to take care of for yourself, it's something that maybe you would want to hire an attorney to take care of that for you too. But everybody who owns an LLC needs to maintain their good corporate records, keep up-to-date articles of organization, make sure that your operating agreement is actually customized to you. You know, a legal Zoom default agreement or something you downloaded off the internet may not actually reflect how you run your business. And then we encourage our clients to document major decisions through minutes, and at the very least to do this annually. If nothing significant has happened, it might be as simple as saying we've reviewed the past year's records and agree that they're in good order, and we approve all the actions of the managers for the previous year. Another thing to make sure that your clients are doing, and that you're doing as well as a business owner, is to actually conduct business in your company name. So if you're entering into a contract, you want to make sure that the party to the contract is the business, not you individually. If you're buying assets that you intend to be owned by the company, register them that way. Or if you need to own assets in your individual name, but you're, for example, a vehicle, you might buy it personally, but if you're operating it as a company vehicle, you need to make sure that you have a lease in place between your company and you individually, even if it's very simple. And this is probably not a surprise, but it's surprising. It is very easy to develop bad habits about this, where you commingle personal and company funds. And this happens especially if you have a startup business, or you're taking all the cash out of your business as it comes through as income. When something major comes up, then often that comes back from your personal wealth. So in that situation, we always recommend clients have a separate business bank account that's tied to their separate business tax ID, and personal bank accounts that are tied to their social security number. And if I needed to loan my company money or contribute capital to my company to pay for major expenses, I would take that money from my personal account, move it to the business account, and then distribute from there.
Hey, Brittany.
Yes.
I will give you a chance to breathe and give out the second code, everybody. The second code to write down in order to obtain CLE credit for today's presentation is the word plant, as in PLANT, plants. That is your second code for the day. And please, Brittany, feel free to continue with the education. That's going great.
Thank you. Just a little bit, we touched on this, but I can't emphasize how important it is for your operating agreement to really reflect the business owner's reality. And this is, we'll talk more about this further along in the presentation, but the operating agreement is a critical part of determining what happens if the member of the LLC becomes, or the manager becomes incapacitated or passes away. and how the business can be sold or transferred to somebody else. But just a few things. If your client is a DIYer and they're bringing to you their LegalZoom operating agreement, something that you can look at as you're reviewing that to it maybe point out why it should be drafted professionally is, does it have appropriate language regarding your tax status? Are there clearly defined duties, obligations, and limitations of the manager, and privileges and restrictions of the members? If you're a partnership, you might think about tag-along, drag-along rights that deal with what happens if a partner wants to sell to a third party. Business succession language, what happens if somebody becomes incapacitated or dies. I already mentioned the specific language regarding PLLCs or series LLCs, whether or not, especially in a partnership, how are you going to resolve disputes? Do they want to have a mediation arbitration clause? Would they rather that be handled in court? When will profits be distributed versus reinvested? And will the company be allowed to require capital calls of members? Let's see. On a partnership, the audit regime language is necessary. And if an S-Corp election is later made from an LLC that started out as a disregarded entity or a partnership, we always recommend amending and restating the operating agreement to include that S-Corp language. This is just going to give you better protection against creditors. In some states, the operating agreement for a multi-member LLC will limit the judgment against a member to a charging lien. Okay, so let's talk about how LLCs fit into a client's estate plan. So obviously, one of our goals as estate planning attorneys is to help our clients avoid probate and adult guardianship. So how should you own the LLC? Just like any other asset, a membership interest in an LLC is subject to a probate if you haven't done proper planning. And generally speaking, if your client has a trust-based plan, then the trust should own the LLC membership interest. There can be some exceptions to that, if it is separate property or if it is not allowed under the operating agreement, you might need to plan around that. But assuming that the operating agreement allows for ownership of the LLC membership interest by a trust, and the LLC already exists, you can transfer it pretty simply. We have a simple, one-page assignment agreement and then a company minute that authorizes the assignment. And if we're forming a new LLC and our client has a trust, then we make the trust the member from the beginning. This is another opportunity that you can make sure that your client's bases are covered by issue spotting on overlapping things, and also generate more business from the same client in a way that still really adds value to what you're providing to the client. If you're doing LLC work and none of the members have all of the members own the interest in their individual names, then that might mean that those members are prospects who need estate planning, and vice versa. I will say that if you are funding a trust with LLC membership interest, or you're creating a new LLC, you might want, it's a good practice to consult with your client's accountant or CPA about any adverse consequences to the ownership structure so that you can plan accordingly. And also, when you're thinking about funding a trust where there's multiple members of the LLC, the operating agreement probably will require consent of all the members unless it's expressly um, um, allowing a trust of an individual to be transferred. We're going to talk down the road and even more in kind of presentation, the second part of this presentation, about business succession planning opportunities that address the same things. So what happens if a member becomes incapacitated? And this is a really important question to ask your client, because if they haven't done proper planning, then you can almost guarantee that there's going to be continuity issues with the business operations. If the member is an individual and there's no designation of who could act, then a guardian might need to be appointed. You can circumvent that with a thorough, durable power of attorney that gives business powers. So that is, easy to plan around with a little bit of foresight. If the member is the trust and the grantor of the trust is the person who becomes incapacitated, then the successor trustee steps in and can do things like vote on issues, like appointing a new manager or winding down the business or selling the business. We also recommend in the business planning that we do for our clients that they have documented emergency plans for a short-term situation. This would be similar to like the OBA's recommendation that attorneys have a plan in place that talks through what happens if we become incapacitated, how are our clients' interests protected, and where do we keep client information, and project statuses, etc. And then long term, you're going to look at the operating agreement and the buy-sell agreement for direction. And if you don't have that, then state law default rules will apply. The other opportunity, just to in thinking about holistic services to your client, is to ask them about how they're insuring against that risk through insurance. Is short-term disability insurance or long-term disability insurance appropriate? Is business interruption insurance appropriate? That's something that a lot of people aren't even aware exists. Basically what that is if you as the business owner are the primary driver of revenue and you have either a short-term or long-term accident that prevents you from working, it's an insurance that's tied to your disability insurance that covers all the operating expenses of your business, so that you can make sure employees are still getting paid and rent's getting paid, etc., while you're bridging the gap between coming back to work or transitioning out of your business. Your operating agreement should state the process of appointing a new manager if the appointed manager is unable to act, and typically that's members voting. So the agent and the durable power of attorney would be the person that voted, or the successor trustee. So if a member dies, then and they own their membership interest individually, then often a probate is required. If the member is a trust, then that's usually avoidable. The successor trustee can act through trust administration. But you're going to check what the operating agreement says, and if there's a buy-sell agreement that where the partners have contractually agreed to certain terms upon the death of one of the members. And again, if there's no pre-planning, then state law governs. And one thing to keep in mind is that an operating agreement and a buy-sell agreement will address the contractual obligations of the parties, but it still might be subject to probate if it's in the deceased person's individual name, especially if it's a business that is going to be sold to a third party, because part of the buying members' due diligence is that the membership interest is unencumbered, and so sometimes they'll require a probate to do that. I just recently had to do a probate for somebody who had a terminal illness. They knew that they were dying. They were in the process of selling the business and hadn't closed yet. And because the LLC was owned individually, we had to have a personal representative appointed before the sale could be closed. And it was a service-based business, and the lag in planning could have, arguably significantly decreased the value of the business. Luckily, the buying party was very sympathetic to the situation, but it would have been so much easier if the trust that this client had actually owned the LLC. So how do you plan for the beneficiaries of a client, a business owner client? And, one of our primary goals as estate planning attorneys is always to help our clients achieve their goals regarding how they pass down their assets to their heirs, and in a way that keeps as much conflict out of the picture as possible, both with regard to the heirs of the family, and also when you have a business, your partners, your employees, etc. But one thing that gets a little bit more complicated when your client's primary assets are a business is how you make distributions when there might not be a lot of liquid cash. And so, in a situation where the primary assets, retirement accounts and the sales proceeds of the house, etc., and a client intends for everything to be distributed equally among their children, it's pretty easy to say, we've liquidated everything, and here is what's fair, these equal distributions. But when you have a business and it's not a liquid asset, that is a much more complicated discussion. It's especially complicated if there's one child in the business that intends to kind of take over for the incapacitated or deceased parent. And there's other children that have no involvement and no intention of becoming involved. It's also not really fair to the child that's worked in the business for there to be equal ownership among their heirs, who then have an equal vote but don't have any idea how the day-to-day business is managed. They're going to have very conflicting ideas about what's their best interest if profits are reinvested in the company versus distributed to the members. So having those tough conversations is necessary to help our client think through these things and think about how we can plan around the conflict so that we can come up with an equitable way to accomplish all their estate planning goals. And really this is mostly done by thinking about it holistically. And sometimes it involves starting the succession planning during the client's lifetime, or purchasing life insurance that will create cash for the other heirs. But whatever the solution is, it's often at least a good idea to consider thinking about hosting a family meeting to talk through the whys, especially if a client is concerned that people won't understand why they made their decisions. It's also really important to make sure that you think through these things, because if this becomes a high conflict situation, it's going to impact the business. And then everybody loses. The value of the business can plummet. Key employees can leave. And then what you have to sell or benefit from on an ongoing basis is much less valuable. So in thinking about business succession planning options, and I'm going to go through these pretty quickly because we'll talk more about this in November, but you really have two different paths. You can sell the business or you can gift the business. And when you're selling it, they're depending on what your goals are and what the situations are, you can set it up to sell it to a family member, to a key employee, a partner, a third party, and then sometimes for estate tax planning purposes, we're selling it to an irrevocable trust that then benefits the family members that are either going to be running the business or going to be benefiting from the sales proceeds of a business interest that has appreciated significantly in value. During our lifetime, we can outright gift membership interests, but that typically has tax consequences. But especially when the business is something that puts your client on the radar to be subject to estate taxes, there are lots of tools like a grantor retained annuity trust or an ILET that can be tax efficient ways to transfer the interest of a business owner and accomplish multiple goals at the same one. And then if you don't have an estate tax issue or other motivation to use kind of advanced estate planning tools, you can still do it via your trust at death, and or outright if you want it to go through probate. So just a couple of tools to be aware of that are necessary to formalize and protect business relationships that you're definitely going to want to have in place if, as part of the discussion that you're having with your client about their estate planning, is what is the succession planning. The operating agreement, hopefully by now you understand why that is important. But also a buy-sell agreement can be very powerful, a key employee agreement, and then documentation like loans or promissory notes, etc., that are going to be critical in clarifying the terms with whether you're selling it to an irrevocable trust or a family member or a key employee. And just something that you have to be extra sensitive about when you're working with a business owner client is there is often conflicts of interest because the business is an entity, your client is an individual, and then the partners or the beneficiaries of future business owners are also potential sources of conflict. And so it's you really have to think through who you're representing, where a conflict of interest might exist, and make sure that if you're if it's safe to move forward and in the client's best interest to move forward, that they understand the risk of the conflict of interest and have provided written informed consent. Even if they're ready to move forward, if you know that their interests are fundamentally antagonistic, then you can't represent both of them. You can, however, call one of your colleagues and that understands these issues and can work collaboratively with the goal of a peaceful transition and a peaceful resolution that benefits everybody, and work together to make sure everybody's interests are represented. And then I just want to touch on, the collaboration is always important, but it becomes especially critical if you are working with business owners. You really need to encourage your clients to have a team approach, and as the estate planning advisor, you also have to understand where you might have blind spots. Do you understand the tax consequences of the strategies that are required to accomplish your client's goals? Are there financial tools that might solve problems? And if you're not comfortable with business law situations, should you be co-counseling or collaborating with a business attorney? These are just a couple of issues where tax issues can really kind of bite the attorney if they don't understand. So I just wanted to point them out. Basically, determining the initial tax status, thinking about what happens when members are added or removed, or if the business is going to be sold, how the sale is structured can often have different tax consequences. And, obviously, if the business is very valuable, estate tax planning is important. But even if not, there are tax consequences to the tools that you use to accomplish the business succession planning. And so it really is necessary to think through the options, both from the legal perspective, but also the tax planning perspective. All right. Any questions?
All right, we did get one question that said, what succession strategies do you recommend or use for single member PLLCs?
So I think it depends on what the client's goals are, right? So if they're and what the line of business has the business been structured in a way that it has value, even if the professional is no longer alive? If you're like, for an example, using a law firm, if your plan is that you walk away from the business and it is going to be unwound, and there's not really any value to anybody else, then what you're really focusing on is how to make sure that your clients aren't penalized because of your death or incapacity. And so that's just really identifying who could step in and who could make sure balls aren't dropped. If you have assets or a book of business or reoccurring revenue that is valuable, then you're looking at succession planning the same way as anybody else. So it might be that your business is sold to a third party, and then the cash proceeds are an asset of your estate, or it might be that you're identifying a key employee or a retiring attorney looking for another attorney that's interested in kind of taking over their practice or buying out their practice as they transition into retirement. So it really just is very dependent on what they're hoping to accomplish and how their business is structured.
All right, if we don't have any more questions, which we'll be here for a minute or two more, so please put your comments and questions into the chat box if you do want a question answered before we get out of here. But I know you're also waiting for the third code. The third code is pecan. And don't get me started if you call it pecan. Pecan is PECAN. That is your third and final code for today's CLE presentation. The link to submit your CLE credit is posted in the comment section on the right side of your Blue Jeans app on your computer. The course ID is also there. If you have questions about that information because you can't find the chat box, all you have to do is email, call, or send me a text message. And if nobody else has any other questions, then we're going to let Brittany and her wonderful mind on business planning and succession go until the annual meeting in a few months, where she has graciously said she will give us a part two, since we, get this intro course and we know there's so much more out there, and Brittany's got it in her mind and ready to share it with us. So we will see her in November for a part two. So have your questions ready for part two. But other than that, if no questions are there, we'll let our speaker go. So thank you so much, Brittany. It was wonderful, and we cannot wait to have you back in November.
So just one final thought. If you're new to estate planning or looking to expand your existing practice, I'd really encourage you to think about where there is overlap in business planning. It's for me at least, it's a hugely satisfying way to serve my clients. I feel good when I know I'm able to look at something holistically and provide a better plan because it's more customized and provides more asset protection. It's, when you draft trust and wills and powers of attorney all day, year after year, it can get a little mundane. And so working with business owners is a great way to get to think outside the box and have fun with it. And it also, not only will you have happier clients, but you'll have new revenue lines that just coincide, pretty seamlessly with your practice. So if I can ever be a resource, please reach out. My email is on the screen, and I'm happy to collaborate or provide guidance.
Well, thank you so much, Brittany. And Jerry, to answer the question, yes, we will get the PowerPoint on the Estate Planning Probate and Trust Section discussion board, and we'll try to do that in the next day or so that everybody will be able to look back on the PowerPoint and get her thoughts that she put down, because everyone's got to steal them now so that they can use them, and because we heard from the best. So thank you so much, Brittany. Again, can't thank you enough, and we'll see everybody next time. Have a great day.
Thank you.
Bye.
Bye.